Hello there and welcome to yet another episode of Know Your Laws, where we talk on matters to do with law, justice and legal affairs to educate you, help you and learn new laws. Today we are going to talk about alternative dispute resolution. How can you resolve a dispute without going to the court? And to join me in that discussion is my guest, who is an advocate of the High Court of Kenya and also an expert in the dispute resolution, that is Bruno Situma. Welcome to the program, Bruno.
Thank you very much for hosting me, Chris.
Yes, and just to get started to this discussion, everybody runs to the court to have their dispute resolved, unknowingly that they can do that without even stepping or rather taking the case to the court. How would we define alternative dispute resolution?
Yeah, precisely as you've put it, everyone seems to run to court to resolve disputes. But there are mechanisms of resolving disputes outside the court system, and that is what you have aptly called or referred to as alternative dispute resolution mechanisms. So basically the Constitution of Kenya, Article 159 to be precise, encourages parties to resolve disputes outside the court system or outside the established legal systems or outside the systems that have been established by the state.
Just staying with that alternative dispute resolution that the court allows for a dispute to be resolved out of court, what are some of the ways that that dispute can be solved outside the court?
Most of the time, the ways in which the disputes can be resolved outside court, there are quite a number of them, but I would say parties can negotiate, that is basically engage in a push and pull between themselves until they find a solution. We have methods such as conciliation, we have methods such as negotiation, such as mediation and arbitration. So basically for mediation and negotiation, the parties find their own solutions. For arbitration and conciliation, the parties involve the services of a third party other than the judges and magistrates in order to resolve that dispute.
So now, considering you've mentioned about mediation, arbitration, and reconciliation, for someone like who wants to resolve a case through mediation, now that is what we are going to major in this particular episode about mediation. What is the process like for mediation?
First of all, the court system, in line with what I've just said, in line with the provisions of the Constitution, the courts in Kenya encourage parties to engage in mediation. And for that reason, they have come up with regulations that guide parties in terms of how they will undertake mediation. Now, basically for mediation, what happens is the two parties engage in resolving the dispute with the help of a third party. I think the viewer must be able to be informed that as the parties engage in mediation, the third party does not come up with a solution. The third party only aids in assisting the parties to come up with their own solutions. And some of that aspect of mediation could be between the parties themselves. The parties could decide to engage in mediation, or in cases where they have filed a case in court, the courts could screen that case and refer it to mediation. Currently, the most common cases that are usually referred to mediation are commercial cases, that is a dispute involving money, or family cases, because family disputes are disputes between people who know each other very well.
And so much is in the mediation process. Why would such cases like family matters and the commercial cases be referred for mediation apart from following the normal court proceedings?
The most common reason that comes to my mind first is because there is an aspect of relations where we involve family disputes, such that if a family dispute, if it's a dispute between parties and it involves family, there are relations that continue to exist after the dispute, right? So if these parties are able to be led through a process that enables them to come up with their own solutions, then perhaps the solutions are more impressed between the parties, and the relationship between the parties remains better even after the dispute is resolved. And the same perhaps applies to commercial disputes. So you'll find that perhaps people are business partners and they have a dispute and they need to continue doing the business together after that, right? So it only makes sense that they come up with solutions on their own, rather than throw their dispute to a third party who does not have or who does not appreciate the kind of relationship that these people have, and therefore the kind of solution that this person comes up with is sort of abstract, right, without understanding the underlying relations between these two parties. And for that reason, perhaps I would say it makes sense to have commercial and family disputes referred to mediation.
And in any case, if someone with a family or a commercial case or other dispute goes to the court, at that point, does the court choose to proceed with the normal way of having to find a solution in that matter, or does the court revert them back to alternative dispute resolution?
Actually, before the 2010 constitution, we didn't have rules and regulations that govern mediation. The advantage that we have with the 2010 constitution is it made alternative dispute resolution a constitutional principle, right? And for that reason, then parties decided, the court system came up with a set down rules and regulations that govern how the mediation process will be taken. I think that the mediation regulations of 2015. So mediation is not done in abstract. It's not some sort of guesswork process. It's a very well laid down process, and for that reason, then, if the courts get these matters, there is a registrar, for example, a mediation registrar, who screens all matters that are filed in court, family and commercial disputes, and decides that, going by the facts set down in these pleadings, it will make good sense for this matter to be referred to mediation. So court-annexed mediation, for example, can either be initiated by the courts on recommendation of the mediation registrar, or the parties between themselves can decide and say, okay, we feel that this is a matter that can be referred to mediation.
And now let's remain about with the court-annexed mediation. That is, the court itself now decides that we're going to mediate these parties through the registrar of mediation. What is the process like once a case, a commercial case or rather a family case, has been filed at the court, and now the court now has to take it for the mediation? What is the process like from the start until the end of it?
First of all, yeah. So once the court decides, or once the parties decide that it's appropriate to refer this matter to mediation, usually the registrar is notified. So the court makes an order directing that the party be referred to mediation. Once it comes to the registrar opens a separate file for mediation, right? Because so once they open that separate file for mediation, the parties are usually notified within 7 days that that file has been opened, and then the registrar will propose. The registrar will propose that will propose names of mediators. So usually 3 names within 7 days. 7 days of the matter being referred to mediation, the registrar proposes 3 names of mediators. The parties will either choose between the 3 names or any of the 3 names, so that that person, usually a certified professional mediator, and the registrar has a list of everyone who is certified to practice as a mediator. Alternatively, if the parties are not comfortable with any of those names, they can also propose their own mediator, or a mediator they are comfortable with, to handle that matter. And that should happen within 7 days. The registrar will then notify the mediator, who has to engage in his first sitting within 7 days. But the long and short of all that is, once the mediation process is on, it has to be concluded within 60 days, which of course is faster than most court processes, right? Yeah.
And now, as a party in the mediation process, of course, these are 2 parties that are in a dispute, maybe one party and the other party. Now there is this mediator that has been selected by both of them, provided by the court. What is expected of both parties in regards to now the mediation process once they have the mediator?
Mediation is quite a complex process. And the reason why it becomes complex sometimes is because the parties are the ones who come up with the solution. So if I have a dispute against somebody else, the mediator will not offer solutions for me. What the mediator will do will be to provide an environment that enables the two parties to come up with a solution. So sometimes you will find a situation where parties engage in mediation, there are breaks. Usually it's part of a tactical, it's usually part of a tactical approach by the mediator to allow breaks, to consult both parties. So sometimes where you have a mediator, you will see a situation where the mediator even calls one of the parties aside, right? Mm-hmm. And if the other party is not aware, they might think that the mediator is then colluding with the other party, right? But the long and short of it is, even when that happens, assuming the mediator decides and calls you out of the mediation room, perhaps to just discuss and get to see what reasoning you have behind your approach, right? I need to know as a party that despite all that, at the end of the day, the solution will come out from me and you, and not the mediator, right? Mm-hmm. So they might call you out and perhaps just try and find out your reasoning behind your approach, and call me out and find out why I'm thinking that way, or why I'm advancing that line of thought. But the reason for that is to enable the mediator to be able to come up with an environment that enables him to come up with to help the parties come up with a solution that fits both of them. Mm-hmm. So basically it's a push and pull between the parties, but the mediator's main job is to create an environment that leads the parties towards a solution of the dispute, mm-hmm. or resolution of the dispute.
And now, because this is a court-annexed process that mediator has been provided by the Registrar of Mediation from the court, yes. And there are two parties in dispute. What happens now if one of the parties decides that they don't show up for the mediation process sittings, and one party just shows up? What are the consequences, considering that this is a court-annexed process?
First of all, I think it's important to understand that despite the fact that mediation is court-annexed, none of the parties are bound to come up with a solution or to ensure that the dispute is resolved. So like I said, there will be that push and pull, and of course, even with that push and pull, the parties need to also understand that none of them is bound to come up or to ensure that the dispute is resolved, because the whole aspect of it is the matter is already before the court, right? And the court feels that these parties still have a chance to resolve this matter between themselves in the best way possible, right? So in case the push and pull does not result to an outcome that effectively resolves the dispute, and within 60 days, the mediator has an additional 10 days only. So maximum 70 days. After the 60 days, the Registrar of Mediation is informed by the mediator that we are yet to come up with a solution, and depending on how far the mediation process is, sometimes they will call it off and report to court that the parties are unable to resolve the dispute, or they will request for an additional 10 days if the process is close to completion. But in case they are able to resolve, they report to the court the outcome. They sign a mediation agreement and file it in court as a judgment of the court. The court in that case will just adopt it. In case they are not able to resolve after the 70 days, what happens is they report back to the registrar, who reports to court that the parties are unable to resolve the dispute, and in that case then the court will take up the matter and deal with it like any other normal matter that has been filed in court, mm-hmm. outside the mediation process. Mm-hmm. Yeah.
And now, at that point where they have disagreed totally, until now the case, or rather the dispute, goes back to the court and the court adopts it, what is the consequences of such a move, having to deny mediation? Until that point now the court takes over the case?
Perhaps the right way to put it will be this. I would say that once the matter is referred to mediation, you remember I said that a separate file is open. And anything that happens within that process, anything that happens within that process of mediation is actually recorded in a separate file outside the court file. So chances are the court might not even be able to know who among the parties rejected the proposals, right? Because it's a separate file from the main court file. And I would say that, of course, the only effect will be to elongate the process for the hearing, and perhaps the parties will be engaged in the dispute for some longer period of time. And I think what I should be quick to point out is, and to the viewer, is that dispute resolution is a very expensive affair to both parties. So when somebody gets into mediation, despite the fact that failure to mediate might not really affect what the court thinks, because it might never get the chance to see, the parties themselves also continue to suffer the costs, and perhaps the outcomes are not as good as you would want. So the court might not be affected in any way, but the parties certainly will suffer the outcome of failing to, will suffer additional costs by failing to mediate.
And now, talking about the mediation annexed by the court, the difference between a mediation initiated before a case is filed in the court and that one that has been filed but the court has annexed for mediation. What is the difference between those two forms of mediation?
The first bit that that will come to my mind will be the issue of enforcement. So when it comes to court annexed mediation, once you find a solution or you resolve the matter and you enter into the mediation agreement, what the court does is it says there was a matter that was filed before us, and it just takes up the contents of the agreement and records a consent. A consent is basically an agreement between the parties before the court. So once that consent is recorded, then that can be extracted as an order of the court. And once it's extracted as an order of the court, then either of the parties can enforce that using the normal legal process. Now, where mediation is initiated before filing a matter in court, what usually happens is the mediation agreement will bind the parties. But at the time of enforcement, it becomes different, because now in that case you have to go back to court, perhaps sue this person for a normal breach of contract, and what will happen then is it makes the case easier, because if the mediator is there, they can say that this is what was recorded, right? And the court will be inclined to perhaps take it up. But what I'm saying is, when it comes to enforcement, if you enter a mediation agreement before before you file a matter in court, you have to go to court before you're able to enforce it. If it is court annexed mediation, once you enter the agreement, it's taken up by court and you're able to enforce it without necessarily going back to court.
And because mediation has been adopted by the Constitution of Kenya, of course, and I think there is also an act on the mediation process, that is alternative dispute resolution. Are there significant cases that, regardless of the mediation being endorsed by the Constitution, are there some of the main cases that cannot and will never undergo mediation?
Right now, the legal platform is a bit different, or the legal approach is a bit different, because now we have very strict timelines for presidential election petitions, and they have to be resolved within 14 days. So I would not see the practicability of having a presidential election petition being referred to mediation, for example, unless then the mediator is able to resolve that within 1 or 2 days and report to court that this is something that we have resolved. But then again, in that case, I don't know what kind of mediation agreement will be filed, which will fit within the requirements of the Constitution. Perhaps they would say that one of them has accepted for a repeat election. I don't think that will be possible. So for most constitutional matters, it might be a bit difficult to refer them to mediation. Yeah.
And now there is mediation and arbitration. Some of the cases undergo mediation and some of the cases undergo arbitration. What is the difference between mediation and arbitration?
They are quite different processes. I think the most common that I would look at, or the most common that I would identify, is the decision maker, right? So for arbitration, what happens is a third party goes through the case and makes a decision for the parties, or a decision that binds the parties. Remember, I started by saying that for mediation, the parties find the solutions themselves. So that will be something that I would really look at. Number two, when it comes to the issue of arbitration, most of these arbitration proceedings are usually commenced through an agreement, that the parties agree that in case we have a dispute relating to this matter, then the matter shall be referred to arbitration. And you might see that some of those contracts or agreements that parties enter to expressly expressly have a clause called an arbitration clause. Now then, in that case, you would not refer such a matter to mediation, because it is contemplated within the agreement that parties will get a third party to make a decision for them. So basically, that's what arbitration is all about. A third party who comes in, who is appointed by the parties to make a decision that is binding to both parties.
What does the court look at so that it can decide that we need to do mediation for this particular case?
I think the court, the screening process is quite a technical process in terms of coming up with what would qualify for mediation. But the most important is, for me, the relationship between the parties would play a very important role. So if the parties are parties that know each other so well, and there is need to retain that relationship after the dispute, I think that will be an initial pointer. And for just so it's just clear, there is a professional person who sits on the desk every day to screen cases and apply different aspects to it, and determine that this is ripe for mediation. Some of them are also cases where we have a lot of emotions. Emotive cases sometimes drive themselves, as a dispute resolution expert, sometimes I think that cases that are very emotive drive themselves away from facts, such that people stop looking at what the facts are, and they just decide that because I don't like this person, I will not accept anything that they say. So in that case, then the court will not be able to really handle such a case without, first of all, trying to reconcile these people, and the best person to do that usually is a mediator, who would then reassure the parties that there is life after that dispute, right? And that the emotions are not working anything towards, are not helping either of them towards resolving the main issues on the table, the main issues that face the parties. So I think the emotiveness of the case sometimes would require that the matter is referred to mediation first before even the main facts are handled. And sometimes when such emotive issues are referred to mediation, the issue is not even to resolve the main issues. It's just to be able to bring the parties back to their senses, that let us stop the emotions, let us face the facts so that we can resolve the issues. And in that case, perhaps, even if the mediator reports back to the court that the parties have been unable to resolve the issue, you'll find a situation where the relationship after that looks a bit better.
The mediator has reached an agreement with the both parties, and now it's time to enforce this particular agreement. What are the consequences if one party fails to honor that particular enforcement of the agreement?
I think that will now get back to, that will actually get back to normal, to a normal process of enforcement. Because once it's adopted as a judgment of the court, then you can extract what we call a decree. You can, if it's a money, assuming it's a commercial dispute and somebody is supposed to pay money, then in that case, once you have the decree, you can engage the services of an auctioneer, you can commit somebody to civil jail. Basically, the normal process of enforcing a judgment takes shape. Because what happens is, for mediation, so that we are just clear. Mediation is a process that comes in between. Remember that perhaps there was already a case that was filed. And what the court has just done is it has given a chance to the parties to come up with their own solution. But once that solution is brought back, then the court takes charge again. That is why it is court annexed. To be annexed for me, I think, is to be attached to, right? When something is annexed, it's attached to. So even when you refer a matter to mediation, and especially where it's court annexed, what we are saying basically in lay terms is the court has said, go through mediation, but we are still watching over you. Yeah, we are still watching over you. So once you're done with your mediation, you have to come back to us, so that we conclude the whole process that you started by bringing this matter to court, but with the assistance of the parties, right? So basically, that's why I would say that when it comes to enforcement, then we will literally be back to the court process, right? So the court enters judgment and says, the parties have given us this judgment, we are taking it up. Now we can proceed with normal court process until the time that execution will, the terms of this judgment will be met fully. Yeah.
What would be your final advice to someone in a dispute and they want to either make a resolution before going to court, or one feels they need to go to court, let the court find for us a mediator? Which of these would you advise to our viewers?
I think, Chris, that's I would say a trick question, because lawyers, if I advised everyone to resolve their disputes without coming to lawyers, perhaps I will not have a job. But that's on the side. I think issues regarding to alternative dispute resolution mechanisms and mediation are things that I would encourage any party to attempt, because especially for mediation is a very cost-effective way of resolving disputes. I know most people who have engaged in disputes understand that dispute resolution is a very expensive affair. So I think as a parting shot, I would ask anyone out there who has a dispute to consider mediation, arbitration as dispute resolution mechanisms. And that will go a long way into saving their pockets money spent in dispute resolution.
And I agree. Everybody wants to spare that cash for dispute resolution. Yes. And that is where we wind up on this episode on Know Your Laws, where we have been talking on matters to do with law, justice, and legal affairs. Today, majoring on alternative dispute resolution. How can you just resolve your dispute without even stepping in a court door? That has been my guest, Bruno Situma. Thank you for making time to have this discussion. And that is where we wind up on this episode of Know Your Laws. My name is Chris Ambu. See you on the next episode. Goodbye.